Today we are hosting a webinar, and the webinar is called Family Law 911. The topic is what to do and what to know when you need to take immediate action in your family law case. And so I'm going to be joined here in just a moment by Michelle Dellino, and she'll introduce herself and be delivering a lot of great information today. I'll take just a minute to introduce myself. My name is Melissa Rosenberg, and I am a licensed therapist here in the Seattle area. And one of my specialty areas is working with clients who are dealing or navigating all different phases of the divorce and separation process. So I do work with clients who are early in the stages of trying to determine whether divorce is their best option while they're navigating their often very emotionally complex family law case, or clients who are on the other end post-divorce and trying to pick up the pieces in their next chapter. So that's one of my specialty areas, but today I'm here as a facilitator and moderator for this webinar. And what I want to invite you to do is to listen to the great information that Michelle is going to provide, but also to ask questions. And there's a couple different ways you can do that. If you pose them in the Q&A on the Zoom screen, I will, pitch those questions to Michelle or get those asked and answered the best that we can. I do want to let you know that if you put a question in the Q&A, you have an option to mark yourself as an anonymous attendee. If you don't do that, your name will pop up with the question. That's totally fine too, but just wanted to leave that to your discretion. And the other way that you can ask a question is through the chat. And I'm setting up the chat right now so that attendees can only chat with me. And so if you put a question in the chat, I will just be the one that sees that, and I'll pitch that as well. So a couple of different ways you can ask a question. We'd like to answer as many questions as we can. I do want to also be clear to say that if you're asking a question, it can't be overly detailed or case specific, or we're not going to be able to dive too deep into that. More general questions are going to be what's appropriate. So that's me, and that's the format, and I'm going to turn it over to Michelle now to introduce herself and begin our webinar.
Hi, I'm Michelle Dellino. I'm the owner and managing attorney of Dellino Family Law Group. We have offices in Seattle and Bellevue, and we actually handle cases all over Washington State. Thanks for being here today. I've been practicing family law for about 15 years. I also have a background in criminal defense, although I don't practice that very often anymore. And the takeaways before we get started for you to know is that I am an attorney, but I'm not your attorney, unless, of course, you have retained me and you happen to be watching this webinar. But I'm going to give out some information today. Nothing that I say is legal advice. If you want to receive legal advice, you need to have an attorney-client relationship with an attorney. So this is here for your information. I hope it's helpful. I think family law matters can be super stressful, and the best thing you can do is get as much information as you can. So by being here and getting information today, you are taking an important first step. So you should feel good about that. I'm going to go ahead, and what I'm going to do, like Melissa said, is I'm going to talk about some content. We're here today to talk about family law emergencies. And everybody, I'll just say this as a family law attorney, everybody thinks their family law case is a true emergency. So we're going to talk about the difference between what are true emergencies and what aren't. And we're going to talk about what to do if you have a true emergency and the differences in the different kind of orders you can get and the timeline for that. One thing to keep in mind is that depending on where you are, depending on, and that can not just be, I'm assuming you're in Washington, but if you're not and you're watching anyway, that's fine. Some of this might not apply to you, but it's going to depend on where you are. Like King County's rules are going to be different than Snohomish County, are going to be different than Whatcom County. Like they're different. So these are general remedies and things that you can do, but keep in mind that the county that you're in and the courts that you're accessing are really going to determine the timeline on some of the results that you can get. So hopefully that's helpful for you to know. Let's talk about emergencies in family law. Like I said, there's two things that are really common in family law. One is people think that their emergencies are 24/7. I'm going to tell you why most of them are not. The other is everyone thinks that their other partner is a narcissist. And I'm only bringing that up because a lot of people that are in high conflict situations use that word. And it does not mean that it's not valid in some cases. And it does not mean that the other person might not have narcissistic tendencies. But as Melissa would tell you if she was talking about it, narcissism is an actual diagnosis. And I'm telling you just from a practitioner perspective that if you have an emergency and you go in and you're like screaming narcissist, it's a really fast way to get the court to stop listening to you and think that you're being overly dramatic. You should describe the behavior in all of these situations that we're going to talk about, the actual behavior, instead of using labels as much. I'm not saying anyone's doing that, but that's what courts want to hear. They want to hear about the behavior. They want to hear why this is an emergency, not just putting a label on this person that everyone likes to use. So I hope that makes sense. I think it's just a good thing to talk about from the outset when we're talking about high conflict stuff, right, Melissa? Like it's just, yeah.
Yeah. And like Michelle said, if this is something that's coming up for you, highly likely that your ex-spouse does exhibit narcissistic
Yeah.
traits or qualities. It's just, hard for the courts to hear that sometimes, and you're better off, like Michelle said, describing the behavior and taking those impacts that it's having on you emotionally to a therapist or to your support network to be able to really understand how you're being impacted by being on the receiving end of somebody who exhibits those kinds of behaviors. And we're usually talking about manipulative, entitled, control, dynamics, a lot of toxic communication, things like that. Absolutely. And I think that those are very real, very difficult and challenging circumstances that many of my clients are navigating, many of Michelle's clients are navigating. So the experience is very real. Want to make sure that to really put that out there, but just making sure, like Michelle's saying, that you're using the right language within the court setting so that you're really going to be heard.
Yeah, absolutely. That's the whole thing. You want to be heard. If it's an emergency or even if it's just a routine family law matter, you want to be heard. And a lot of people feel that they're not heard in this process, and I completely understand why. So you want to choose your words carefully. Let's talk about emergencies before we get into different types of action you can take. A lot of the time, it'll be 8 p.m. at night or whatever, and they'll be like, there's an emergency. This is blowing up. I need to talk to you right now. Number one, there's not much usually that we can do after hours, especially if the court's not open. So I want to talk about that. And number two, if there ever is a true emergency, your first call should not be to an attorney. It should be to 911. So when I talk about emergencies are there's family law emergencies and then there's actual real emergencies. So real emergencies are something that need to be handled 24/7. Someone's physical safety is in jeopardy. Or if something does not happen right now, there's going to be some kind of irreparable harm that cannot be fixed. Those are true emergencies. If that's happening to you, you should call 911. We had a client call the office not that long ago who was panicking about something going on, and it sounded like a true emergency. And I was wishing that they had called 911 first because 911 would need to get there. So you need an immediate response. You need someone coming out. Always err on the side of caution if it is a true emergency where someone's physical safety or liberty is in jeopardy, that you call 911 before you call your attorney. Do call your attorney. Like, we want to know what's going on. Whoever your attorney is will want to know, but call 911 first. And there's two reasons for that. One, you want to get that immediate response if someone's in danger. And then number two, just from the perspective of your family law case, you want to document. And if you called law enforcement and there is a report that this came out and this happened, that's only going to help you in your case. So it's really twofold. A lot of people won't call because they're like, oh, I don't want the other party to get arrested, or I don't want someone to get in trouble, or I don't know. But if you felt like it was an emergency and someone's physical safety is compromised, you should absolutely call 911. And then when you call your attorney, let's talk about what we can and can't do after hours or on a weekend. It doesn't mean that we don't want to, but number one, every family law attorney is not available 24/7. And number two, it's going to cost you time and money. And most importantly, number three, there's typically not a lot we can do. So a very common thing that people think is an emergency is my spouse or partner didn't show up for our former spouse or partner didn't show up for our custody exchange, or they are trying to get me to come to a different place, or it's something surrounding a custody exchange. This is a very common thing. They're not following the parenting plan. That is not an emergency. it's not okay, and that person probably should be looking at whether it's a situation to seek contempt or some other kind of corrective action needs to happen, but it's not an emergency. If you call me at 8 p.m. and you're like, this person's not here, I can do anything about it. I can't call the police. They don't care because it's a dispute. If I can't do anything, I can't reach the other person's attorney, I can't be there, there's nothing I can do. So the best thing to do in these kinds of situations is use your best judgment and try to stick as close to the parenting plan as you can. And if the other person's not allowing you to do that, then you just document it. You document it in, an email or Our Family Wizard or whatever your situation is, and then you move on. And you can't resolve, some problems cannot be resolved right in the moment. There's nothing I can do about it either. I can take a note of it and maybe call the other attorney the next day, or maybe we need to seek contempt or whatever, but nothing can be done. And so the best thing for you to do is document and follow the plan as closely as possible. There's other kinds of emergencies that come up that are important situations, but not true emergencies. This is another common one I'm going to talk about. Oh my gosh, my ex-wife took the kids and went and ran out of state. So first you're thinking, oh my gosh, kids are gone, and you're panicking. But a lot of the time that turns out to be they didn't ask permission and they took the kids and they took them to her mom's house in Oregon. Well, that's not like they abducted the kids. You know where they are, you know where they're going, you know that they just went on a trip to their grandma's house that you weren't okay with. And maybe your parenting plan says they had to give notice for out-of-state travel and they didn't do it. That's not an emergency. That's not the same thing as my former spouse or partner has stolen the passports, gotten through security at the airport, and is on a plane to India and never coming back. That's an emergency. So there's a difference between those two types of emergencies. When I say that something's not an emergency, it just means it's not 911 worthy and there's nothing we can do after hours. It doesn't mean that there's not areas for court intervention, whether it's enforcement, contempt, or writ of habeas, different things that you need to do, but there's nothing you can do right at that very that moment. So what kind of things are emergency and what can you do? Well, first thing to know is that if you feel you need emergency assistance, you should reach out right away. Because if you don't, and you have a situation that's time sensitive, it can hurt your family law case. So an example is if there's an emergency situation that's placing a minor child in danger and a parent fails to protect the child, this could be used against that parent. And the court will question that parent's judgment. Well, why didn't you do anything at the time? Like, well, my child was abused by the other parent or in a daycare situation. If you didn't do anything about it and then you bring it up later, it's going to make them question your credibility. And number two, it can also be an issue with CPS where you failed to protect your child if you knew or should have known that they were in jeopardy and you didn't do anything. So you don't want those things to happen. The other thing is that the person who files something first, if an incident has happened, has the benefit of addressing the court first and addressing the court last. And you're bringing it up first because you act quickly and you're not defending on the situation. So if someone's going to say you did or didn't do this, it's better if you bring it up first. Trust me, it definitely is. So an emergency, most of the time, emergencies center around emergency custody. That's just what happens. So what's an emergency order for when it comes to custody? That's an order where a child is placed immediately with one party without notification to the other parties. Most types of emergency custody orders deal with young minor children. And who can get an emergency order? So usually a parent can request an emergency order when the other parent or circumstances presents an immediate danger. So, and that can be a situation where something has happened and there's been a report of a parent doing something that is like serious, like this child is being abused, or there's like abandonment, like the other parent is gone and nobody knows where they are and the child is like fending for themselves, or there's reckless or threatening behavior. There has to be something that is placing that child in imminent danger. If there is, then you may be able to get an emergency order. And here's the thing that happens sometimes. A lot of the time, this is how a family law case starts. That's not ideal, but it's a thing. Like you're in a situation in your home and you see something happen from one parent to your children or to you. That's an emergency situation. You need to take those kids and protect them, and you need to get an order to keep the other parent away. And you can do that. So an emergency order could happen that way. But what's the difference between an emergency order and like a parenting plan, like a temporary parenting plan? This is what I was talking about earlier. It must be a true emergency. The court doesn't like it when you try to go and get a temporary order, because that's all it'll be right away, is an emergency temporary order until there's a final hearing on it. Court doesn't like it if you came in and it wasn't a true emergency. They're going to be like, why didn't you just set this for a regular hearing? You wasted everyone's time and money, and you could end up paying attorney fees. And in general, an emergency situation really is where you can demonstrate to the court when you ask for that emergency order that irreparable harm to you or the kids is going to happen if this order doesn't issue. Court can issue an emergency order without any notice to the other party. However, this doesn't usually happen. If there's a reason to go and get the order and not tell the other parent because they're going to retaliate or something is going to happen, and you can demonstrate why you didn't give notice, that makes sense. However, if the other party already has an attorney, or there's already a case going on, or you're able to give them notice safely, most counties are going to require at least a 24-hour notice of an emergency hearing. Emergency hearing is still a lot faster than a regular hearing because you basically go into the ex parte department and you ask for it. That's very different than a regular hearing, which has to be scheduled weeks out. And unfortunately, in King County right now, it can even be longer than a few weeks. It can be a month or two, which is ridiculous, but that's a story for another day. So an emergency hearing can usually require 24 to 48 hours of notice, or notice at all, no notice at all if there is an actual basis. Then the court will hear at that emergency hearing what the basis is for issuing this order. And then once it's issued, it needs to be personally served on the other party. And there's always a return hearing date. So the other party is always going to get a chance to respond to what happened, and you're going to get a chance to reply to it. But it's going to give you temporary emergency relief. It's usually 2 weeks out, depending on the county. Sometimes it can be a little longer as well. So during that time period, that emergency order has to be followed. Melissa, are there any questions before I keep going?
I do have a question here in the chat. It's about a situation, but maybe it's not super specific, so maybe we could talk about it. If a parenting plan, this situation, a parenting plan was issued back in 2019, but it hasn't been followed since 2020. Okay. So situation, 3 years of this not being followed, and somebody relocates to another state. So what happens then? Who has jurisdiction, and does it have bearing that this parenting plan hasn't been followed in over 3 years?
Okay. If a parenting plan hasn't been followed in over 3 years, here's the thing. If a parenting plan hasn't been followed in over 3 years, then you're in a situation, where the other party, or depending on what the situation is, integration could have occurred. So there could be a change to a parenting plan. There could be a change to a parenting plan. At this point, in a situation where a parenting plan has not been followed, you need a substantial change in circumstances to change it. So if somebody has done something like not followed a plan for a period of time, and it's like 6 months or a year, and you're at 3 years, and then they're trying to enforce the plan, you might want to then go and seek a modification to actually change that plan, because there is integration into your home in the new schedule. So it's not really an emergency situation. If someone then comes up and says, hey, I want to enforce the plan right now, you're going to either have to try to change it. Technically, they should follow the plan, but after 3 years, there's probably a basis for integration, if that makes sense.
Yeah, thank you.
Yeah.
And I don't have any other questions right now. Just a reminder to our participants to go ahead and shoot them my way if you have any questions specifically that you'd like answered.
Okay. Okay. And let's see. Okay, that's the same one. All right, sorry about that. So we're talking about emergency orders. When no emergency exists, the legal avenue for obtaining a custody order or parenting plan is filing a motion for temporary orders. And this is why I was telling you earlier, like, if there's not an emergency, you just need to file a temporary orders hearing. It's probably going to be a few weeks out. And you can do that in the beginning of a divorce case or a parentage case or any number of things. So you would file your moving papers, and then you would schedule a hearing on the court's calendar. That's what's going to happen. Sometimes if you go to seek an emergency order and there's no emergency, they're going to say, well, you should have done this and you have to do that. Or they're going to set the return hearing and not issue emergency relief. So temporary orders can be changed throughout a case if there's a basis for doing so. Once the case is finalized, either by agreement or at trial, the final orders then become permanent and they supersede any temporary orders. Let's talk about restraining orders. What is a restraining order? A restraining order is an official order by a court to help a person, business, company, establishment, or anything else when they're facing domestic violence, assault, harassment, stalking, or sexual assault. Every state has some form of a domestic violence protection order, and we'll talk about that in a minute, and a restraining order law that specifies restraining orders typically for stalking, assault, or domestic violence, and usually those are protection orders, not restraining orders. Since states have their own laws, it's really important to make sure that you are clear on what's going on. So in Washington, you have to recognize that emergency restraining orders are often necessary, but like to protect you. And that's different. A restraining order is different than like an emergency custody order where I went in to try and get an emergency temporary order and then a temporary orders hearing. So you have to decide sometimes between a restraining order and a domestic violence protection order. In some circumstances, a restraining order is more appropriate than a domestic violence protection order. There's a difference in these requests because they reflect on a criminal history search differently. They can be different with employment. They can have different implications on your firearms rights. So first, a restraining order. You might go get a restraining order when you start a case or even in the middle of a case if you feel that persons or property or something else are in jeopardy. And it doesn't fall under a statutory definition of domestic violence. If it falls under a domestic violence type of a lens in that kind of a situation, then if that happens, you're in a situation where you might want to go through for a protection order if it falls under one of those provisions, because it can be a lot higher response time if you have an order. It can have different firearms implications, so on and so forth. A restraining order can be different types of things. It might be something where someone has to stay away a certain amount of feet. It might be something where it places a child with a parent, or it keeps just two people apart. It might be something that's more benign though, which I don't mean it's not a big deal, but it might be something called like it's a do not disturb order, where neither party will disturb the peace of the others. That's a really common boilerplate kind of a term that you might see in a restraining order. And that really just means you won't do some, you can still contact that person, but you won't have contact with them that's not basically in the ordinary course of business, like for a real reason, like, oh, we're working out paying bills in a divorce and I need to find out about paying this account. I can contact you that. I can't contact you and be like harassing you and yelling at you and screaming at you about what happened. You won't, and so, you know, or if you have a child in common, I can message you about pick up and drop off or whatever, but I can't tell you what a horrible parent you are. And like, I can't disturb your peace. So do not disturb orders don't necessarily mean no contact. Restraining orders can be do not disturb orders. Restraining orders can also be next level, where they actually place someone like a child with one person, and so on and so forth. Restraining orders are different than protection orders, because it can take time. Also, this is the other thing too. It can take time to complete a divorce or a separation. So we often see a need for emergency restraining orders, custody orders, and protection orders to give somebody protection while the case is going on immediately, or maybe even after. A lot of the time when people are leaving a situation, they need to get one of these orders. Or if something, you know, because something has happened, or if there is a reason that they have some kind of a fear, they need to get one of these orders. One question is, how long does, what's a protection order versus a restraining order? Protection order is where the behavior that's alleged falls under Washington's definition for domestic violence. And there are, I've done a whole other webinar talking about domestic violence, so I'm not going to get a lot into that today. But if you have something that falls under domestic violence, just in general, it can be physical violence, or it can be an imminent fear of physical violence that a reasonable person would have under the same or similar circumstances. It can be stalking, it can be harassment, it can be what's called coercive control, and there's a whole lot of things that fall under that umbrella. And if those things happen, those are indeed domestic violence. How you get a domestic violence protection order is it can't be someone's harassing you that's a neighbor or a friend. It has to be someone that was a household member, former dating partner, an actual person that qualifies under the provision of those relationships plus the behavior. Then a domestic violence protection order may be appropriate. Domestic violence protection order too has different implications in a parenting plan. So a finding of domestic violence can trigger what we call 191 restrictions in a final or temporary parenting plan, usually a final plan. So getting a domestic violence protection order can make a real difference. It also, like I said before, is a higher order of protection and typically gets more of an immediate response if you have to call law enforcement. It results in surrender of firearms. And these orders can also be issued longer at times, not always, but at times, than a restraining order. A protection order, it can be used to keep you or your children safe. Sometimes you might petition on behalf of a minor child. Sometimes you're petitioning on behalf of yourself. If there are no kids, sometimes it's both. Typically what happens, the process for restraining orders or protection orders is going and getting a temporary emergency order, usually with or without notice, depending on the circumstances, like I mentioned. And then a return hearing will be set after that for either kind. So you hopefully ideally get that temporary emergency order if you need it, and then there's a return hearing. What does a protection order cover? Order of protection stops that person from getting in touch with you verbally, from text, email, in person, social media, any type of communication. Protection order always does that. Restraining orders don't always. They usually are very specific to the restraints that are in place. Protection order is no contact whatsoever. It can even go as far as to protect the victim's children and other family members living in the home and even property. So it really just depends on the circumstances. Sometimes the protection order will protect just the parent and not the kids. Sometimes it will have supervised visits with the children. It really just depends on what that is. Another type of emergency order, it's not a restraining order or protection order, is what's called a UCCJEA order. And I'm mentioning this specifically because emergency custody, where one parent takes a child to another state, might be something that happens in your situation or someone else's who might be listening. So if, let's say, a child and a parent live in California, and you're in California, and then one parent comes here with the child to leave domestic violence, there's no jurisdiction, and jurisdiction means the ability for a court to enter an order against another party. There's no jurisdiction over that child here because they haven't been here 6 months. There may or may not be jurisdiction over the parties depending on their connections to Washington. But that is an emergency. If someone came here to flee domestic violence, they could petition a court here or in another state. UCCJEA it's the Uniform Child Custody Jurisdiction Enforcement Act, and it is relevant in all states. So the state that you ran to might not have jurisdiction over your child, but they can issue an emergency jurisdiction order. They can take emergency temporary jurisdiction and issue a temporary order to protect that child and you. So that's something else that can happen, and that doesn't always happen, but it's definitely an option. Melissa, were there any other questions?
Yeah, I have several questions that have come through. Okay, here's a question. There's a number of questions about some of the similar topics that you're on, but I want to ask this one. This person's talking about not having children. She said she's 69 and hiding from the husband, living in under a confidential address. Had left him after feeling really unsafe. And I guess just trying to figure out if what the best course of action would take is, and this is a bit specific, and so you probably can't necessarily advise, but she's asking about whether she should file for divorce, even though it would come at a financial loss, in a situation where she feels really unsafe right now.
Trying to think of the best way to answer this in a general sense. Read that to me one more time.
Yeah, she's hiding from her husband,
Right now. Okay.
feeling unsafe. Yeah, had
Okay.
left him. It sounds like January. It's been almost a year after,
Are
feeling
there, okay.
unsafe. No children. I mean, she's older, 69, so
Okay.
older than having small children anyway. And wondering about whether filing for divorce, even though it would come at a financial loss, would make sense.
Yes. Yeah. Okay. You're in hiding now. Okay. That's what I'm trying to understand. If it's been a year, yes. I mean, here's the thing too. Divorce is going to cost you money, but it's also going to give you your freedom back. And it might end up putting resources and assets in your pocket if there's part of the marital community that can be given to you. So I think that in your situation, if you fear for your safety and there's a basis for it, at least when you file for divorce, you could take advantage of getting a restraining order or a protection order if it was warranted, and getting that issued when you file for divorce, so the other party can't contact you. If you've had to been hiding for a year, you must be pretty scared, and that's a really tough spot to be in. And you're probably having to rely on friends and family to help you. So ending a marriage, even if there might be some cost associated, would probably be a good idea, so you could financially divide assets, be able to file your own tax return, and do things that are going to allow you to establish your independence. So you might just want to start the case with a restraining order or protection order to give you that security during the case, if that makes sense.
Yeah. Thank you. Yeah. Okay, a handful of other questions, so I'll ask a few of them. Okay, you already answered the question about do not disturb the peace. Okay, if coercive control is found by the court, what kind of protection order is appropriate in that situation? Is there a standard, or would they make a very specified order?
Well, a domestic coercive control is domestic violence under Washington law. So a coercive control, and this is as of last year, the law changed. Before that, coercive control was not recognized as domestic violence in Washington. But if coercive control is found, it's usually in the context of a domestic violence protection order. If coercive control is just if someone is talking about coercive control as far as if someone's talking about coercive control as far as like a finding in a temporary orders hearing, this person engaged in coercive control, it's going to be in the context of that order. But a finding of coercive control can be a finding of domestic violence under the domestic violence protection order statute. So I guess like where the finding was made is kind of what the context is here. But I think the takeaway from this is that coercive control is domestic violence in Washington. So and coercive control is I talked about this on another webinar. It's definitely involved is an involved kind of definition that is a lot broader. As far, you don't ever have to have physical contact with anyone. It can be cutting off access to money. It can be in a form of communication. There's a lot of different things that are coercive control that were never domestic violence before, but it is a form of DV, so a protection order absolutely could be warranted. I hope that helps.
Yeah. Okay, here's another question. If there are no contact, but visitation is allowed, whose responsibility is it to exercise visits? For example, does the visiting parent need to provide an actual schedule? That's a little bit of a confusing
Yeah,
question.
say that again. I'm sorry.
The question says is if there is, I guess, no contact, maybe a no contact order, but visitation is allowed, whose responsibility is it to exercise visits? Does the visiting parent need to provide an actual schedule?
No contact is allowed, but
But they're
get a
having
person's.
visitation. Maybe no
Yeah,
contact with the partners, former partners, but they're allowed to have visitation with the
so
kids.
okay, yeah, okay. No, if no contact is happening between the parties, but they're allowed to have visitation, that party, unless it specifies in the order that that party can make contact, it's usually going to be through like our family wizard or email or something, just to schedule visits, then there is no contact that's allowed. So the party that wants to visit would need to schedule it through a third party. Very often it's through a professional supervisor. You're not mentioning that here. That's why I was just trying to think if that was part of this. But if there is a need for a professional supervisor, like if there is actually a need for a supervisor, then typically the parent who wants to schedule the visitations is responsible for setting that up. And then the visitation location will reach out to the protected party and help coordinate the visits for them. But it's on the person who wants the visits to make that happen. But no, they cannot contact the other parent unless the order has specific provisions that they can do that.
Mhm, mhm.
Yeah,
Okay, thank
I
you.
think that answers the
Yeah,
question.
yeah.
Yeah.
Okay, a few more questions.
Okay.
What if you get a restraining order under domestic violence, but at the end of the trial, you got a plea deal and the restraining order got removed with no notice? Would this affect the divorce case?
A restraining order is never issued. I'm sorry, a restraining order is not issued in a criminal case. I think this person's talking about a criminal case.
Mhm.
An order that's issued in the context of a criminal case is called a no contact order, and those can be removed with no notice to you. A no contact order is a very different. I'm glad this came up actually, because I was going to talk about it if someone hadn't asked. A no contact order is issued, like let's say that someone is charged with a crime. You're charged with a crime, and a no contact order is issued between the defendant and the victim. And you don't get notice of that. You don't ask for it. The prosecutor asks for it, and the court puts it into place. So a no contact order, oftentimes, if someone is protected by one or someone else is subject to one, the protected party will also go and get a protection order, because a no contact order, which is exactly what it sounds like happened here, can end. Sometimes it ends at the end of the case. If you take a deal, just like you said, part of the deal is the order is gone. Sometimes part of the deal is the order remains for a fixed period of time, but those orders can't be renewed. No contact orders that are companion orders with criminal cases, they don't get renewed. There's no authority for them to be renewed. You would want to also have a protection order, a companion order that you can renew and keep in place after the criminal case is over. If your no contact order got dismissed here and you didn't know that was going to happen, they usually should tell you from the prosecutor's office, but sometimes they don't have to. And sometimes they don't. So if that's the situation, your recourse here really would be, this is an emergency because this person is, was charged with a crime for hurting me, whatever it might be. You could go and now seek a protection order and say that the emergency is, I no longer have the protection of the no contact order and I need a protection order. So they're different types of orders. Restraining orders, protection orders, and no contact orders all have different places in emergencies, but no contact orders are always companions to criminal charges, and those are not able to be renewed, and they can really end without you knowing about it. They shouldn't, but it does happen, and there's no obligation for a prosecutor to let you know, or a court to let you know, that a plea is entered and that order is no longer in place. But it doesn't mean you can't say, now I have an emergency. I don't have an order protecting me. I've got to go get one.
Yeah.
So hopefully that helps.
Yeah. Another question I'm going to try to paraphrase. It sounds like this participant is in a really awful situation where the tables kind of got turned against them in their situation. It sounds like there was some verbal abuse in front of children. They tried to sort of take action and involve the police, but then the husband retaliated and filed for divorce. They got a restraining order against her. And so now she's like removed from her kids and, with the restraining order, doesn't have her kids and is feeling like everything's going really terrible. She's asking if you're taking cases and how she might take action in a situation like this.
Okay. We are taking cases. There are 9 attorneys that work here, so we are taking cases. The best thing would be to call and talk to our intake team about what our capacity is to get you scheduled for consultation, see if we can help. When you feel like something like this is the thing. That's why when I started out, I was talking about taking action. And sometimes your situation might be one of those times where something happened and all of a sudden you were accused of doing things, and temporary orders entered and emergency orders entered, and you feel like you're trying to dig yourself out of a hole that you really shouldn't be in, and things are just not going well. And if that's the case, like it is a function of sometimes these situations, and it can be a longer term game to it can be a longer term game to try and get a different outcome if the case starts that way. So you want to have a strategy and a plan, and you want to understand what your risks are moving forward and what actions you can take to maybe change the narrative. So yeah, you could schedule a consultation with us or any other firm, but you definitely should get some help.
Yeah, and we're going to put up contact information at the end of the webinar just in case you don't already have that.
Yeah.
So thank you for that, Michelle. I just wanted to interject for a minute. In a situation where there's immediate action needing to be taken, in any situation where you're maybe separating, everyone's situation is different, but many times it came from this place where you might have felt physically or emotionally unsafe, and so just want to really encourage everyone who might be in a situation like that to ensure that you understand how to create your own safety network, including, involving an attorney to help advocate for you and strategize for you and help make things go as well as they can from a legal standpoint, but also just ensuring your own physical safety and your own emotional safety as well. Make sure that you have people you can trust in your life. Make sure that you have people you can talk to. Make sure you have a safe place that you can go, whether it's with a family member or a friend, or if you're aware of, domestic violence shelters and resources that are out there. Make sure that you have a therapist, who you can work with if you are in a situation. Just about anyone in the world could benefit from a therapist. So, if you're in a situation that's emotionally complicated like this, make sure that you have, your supports in place, because it's really tough to be, in a situation trying to navigate it on your own. So I just really wanted to kind of put in a plug for ensuring your own emotional and physical safety. And if you're also a parent, you're responsible for your children's emotional and physical safety as well.
Yeah.
Okay, a few more questions I'll try to ask here, would the court ever order in a temporary order for the parties to work with a certified financial specialist if somebody's being difficult about creating financial clarity and refusing to contribute from a financial perspective?
So you're asking if working with a financial specialist will help with that?
I think they're asking if the courts could like order that kind of a thing if
No.
somebody's not being transparent. How
No,
can they?
no, that's not the remedy. I mean, you can work with a financial advisor or somebody can consult on your case, but a court's not going to order that, and you don't have to. And really, it sounds like what you need is if someone's not, the only way to get somebody doesn't have to give you their financials unless you follow the right channels to get them. And that is like if you file a hearing where there is financial relief requested, both parties have to file a certain set of documents that complies with local family law rule 10 in King County. Some counties have that rule, some don't. But that's one way to get financials. The other way is to serve discovery. If you serve discovery on the other party and you request certain financials, they have to give them to you unless there's valid objections. And then if they don't, then the process that you have to follow is there's a discovery process you have to follow. And then it basically ends in seeking a motion to compel from the court where this person is ordered to hand over their financials and usually pay you attorney fees. So the reality of the situation is that it's great to have a financial advisor involved, or maybe even like a forensic accountant if you need some tracing or something done. But the court's not going to order those things. You have to set yourself up to get the information by making the appropriate requests, and then you have to enforce those requests if you don't get them. And if you have a hearing set and the other party doesn't file the required financials, the court's not going to be able to consider their position, and they're going to hear that. So that's just something to take into consideration.
Mhm. Okay, thank you. All right, another question. It's a CIR situation, a committed intimate relationship of unmarried partners who are living together. And this attendee is saying that they're struggling with a partner who thinks dividing community property is not morally right, even though the law says it's what's fair. I currently have no income, and he was supporting us at the moment of separation. He doesn't want me to pursue CIR separation. Struggling with feeling like it's unfair to take property he worked hard to earn, but at the same time, I have nowhere to go or any way to support myself, right, as I look for a job. So this person's saying that starting a CIR case would mean they would need to leave the house. Is it possible to request or obtain any immediate amount of money to live off of, knowing that the negotiations could take months?
Well, here's the thing for you to know. You in a committed intimate relationship case, there is no right to spousal maintenance. So you can't get temporary spousal support the way that you could in a
Good question.
divorce.
Great.
What you just can't. So
Yeah.
you're not going to get money to live on that way. You could ask for an order, and this is a tough thing in CIR cases, because you could ask for an order like it's for you to be able to stay in the home during this time and the other person to pay the bills. Sometimes people will say, well, that's trying to get around the maintenance, but it is an order the court can make. So it really depends on the individual circumstances that you have and looking at your financials and your situation. So there may be ways to get some access to funds, or there may be money that is quasi community or community like, which is what we call money earned during a committed intimate relationship. And maybe one party could get a pre-distribution. The problem there is it's not a marriage, and the whole question of whether there is a committed intimate relationship is a question for the trial court. So a lot of the time, a pre-distribution in a CIR case is just not going to happen because there is dispute over whose funds those are. So it can be difficult in a CIR case to actually get temporary funds, and the two things you cannot get in a committed intimate relationship case are specifically spousal maintenance and also attorney fees from the other party. So it might not be what you want to hear, but it's an emergency for you that you need to get money to live on. But at the same time, there's only certain relief that's available in a claim between unmarried partners.
Yeah, thank you. That's great clarification.
Yeah.
Another question. Okay, let's see. They said, what if they didn't get a UCCGA? I don't know what that is, but you can tell us, back in 2021. But it's been around 3 years now, and they're requesting parenting orders. Can the new state get jurisdiction based on the UCCGA? This is the I think this is the same person that said that there was a relocation to a different state and was looking about
Okay, okay,
jurisdiction.
okay, okay, okay. No more, no more, no more.
Okay.
UCC, no, no, no. UCCJAA is if you have an UCCJAA case, you got a lot going on, and I'm not going to be able to give you my ad hoc opinion on it's not responsible for me to do that, like even to speculate. So I can't do that. I'm sorry. But UCCJAA is something you should talk to someone one-on-one about with your situation. Not that I don't want to help, but like I'm just speculating and I don't want you to rely on that, and that's like not helpful to you. So sorry, but I just can't with UCCJ is no. And make sure you work with an attorney who has worked with UCCJA cases before, because intrastate and international custody cases as well can be really difficult and time consuming.
Okay. Okay, there's another question here that's about visitation and it's kind of specific also, so we'll see if we can generalize it. Dad has a DVPO against mom in custody of the teenager. Communication allowed via TP only. I'm not sure what TP means. Maybe you know.
Talking parents.
Oh, got it. Mom refuses to put her dates on the calendar, but then submits to the court that dad's refusing visitation. All right, is dad just supposed to make up a schedule and drop off the kid and hoping mom shows up? Or I guess this is back to kind of who's in charge of enforcing this visitation.
Well, you should have a plan that specifies who has the
Yeah.
kid when. If you don't, you should seek clarification of the plan that you do
Yeah.
have. And if you, that's what I recommend. Like you either need to have a plan and have it and follow it. If you don't, then you need to seek clarification for what the parameters on that visitation should be. It's not on your plate to figure that out. Like, and you don't really want to try to do that because then it could be something wrong. I did want to say one other thing before I forget about and I'm happy to take a couple more questions because I think it's valuable for you guys that have come to watch this to ask questions. You've heard the gist of a lot of stuff about what to do in an emergency. One of them is timing, and this comes up a lot, especially under the protection order statute. What if something happened 6 months ago? What if it happened a year ago? Like, what do I do in that situation? Is it still an emergency? Probably not so much. It doesn't mean that it's not domestic violence. It doesn't mean that you can't do something. But when you're talking about if you went into court tomorrow and said, I need a protection order immediately because of something that happened in December of 2022, that's not going to have a lot of credibility. Doesn't mean it didn't happen, but it means it's not an emergency right now. It means you could probably set a hearing on it if you've waited that long. Unless it's like something happened in the different context would be something happened in December of 2022 and now something else has happened that makes me fear that's going to happen again. Like, oh, there was abuse in December of 2022, and then my partner was completely sober, and then they started drinking again, and they started throwing things around the house, and I'm scared, and I'm hiding in the bedroom. They haven't hit me yet, but I think they're going to. Okay, that's different. Then what happened in December of 2022 is totally relevant. But if it's just we had this fight in December of 2022, and everything's been fine the last year, and now I feel like doing it, that's not an emergency. That's when you set a hearing. So timing is a whole thing. And it doesn't mean that you can't set a hearing, and it doesn't mean that you can't get protection. It just means you need to look at that through the lens of considering whether it's an emergency. So I hope that helps. That's something that comes up and I had forgotten to mention earlier was timing.
Okay. Let's see here. Okay. This is a different kind of a question. Wife does not have name on title and signed a quitclaim deed. Bought the house 7 years before marriage, married 13 years, still paying the mortgage. Wondering if the wife has any claim on the house.
Wait. Again, fact specific, but
Yeah, very fact specific.
if somebody, I'll just tell you this. Here's my general
Yeah.
thing to tell you, and this is something that everybody needs to hear. Character of property, which means is it separate or community? What is the character of the property, separate or community? Character of property is established at the time the property is acquired. The character of the property can change later with a quitclaim or any number of things. Although a quitclaim is not dispositive, meaning it doesn't necessarily mean the character has changed just because you signed one. But when the property was acquired, if it was acquired during a marriage, no, it doesn't matter whose name is on title. It's presumed to be community. If it was acquired during a committed intimate relationship while you were already living together, it's a presumption then that if there is a committed intimate relationship, it is also community-like property. That presumption can be rebutted through tracing or any number of things. But that is the thing. In this situation, does it sound like they owned the home and then the wife quitclaimed off of the home? Is that what that was trying to say?
Yeah. No, it sounds like they owned the home before they were married.
Oh, the other party owned the home before they were married? well, I guess it would depend then, were they already living together and is there a presumed committed intimate relationship? If not, it's not their home. It's the other party's home. If the other party owned it before you got married or before you were living with them, it's their home.
Yeah.
So yeah. And then if they refinanced and now you're married, you probably would sign a quitclaim saying it's not your home.
Mhm.
So
Mhm.
that's probably what happened
Mhm. Mhm.
because the character of property is established at the time it's acquired. It doesn't change just because you got married. It stays that character unless something happens to change it, which has to be the execution of a document and the intent that it is made community.
Yeah. Yeah. Okay, another question that's kind of like an emergency situation. So if somebody's evicted from their home on a restraining order and, still needs to kind of pay bills and mortgage because they're on all these things, no funds to go get their own place now. What are they supposed to do in that situation? I mean, that's a really tough situation for anyone to be in, of course. And is there a course of action?
So if somebody doesn't have access to funds, is
Well,
there,
their funds are tied up in the house they're evicted from
okay.
based on restraining order.
You didn't get evicted. Eviction's a legal
Yeah.
proceeding. So, okay, I was confused. All right, you didn't get evicted. You got out, you're out of you basically are out of the house because there's a restraining order. So you don't have any access to money. I mean, this is going to sound terrible to say because you kind of I don't know. I mean, if there are other funds, if you're married and there are other funds that you might be able to get a pre-distribution from, you could, and this is the thing too, we're in a no-fault state. So even if there is a restraining order against you, it doesn't mean you don't get access to money. Like
Mhm.
it might mean you have to stay away from somebody, but it doesn't mean you don't get access to money. So if there are funds and you need emergency access to money because you don't have a way to live and the other party does, you may be able to seek attorney fees. You may be able to seek a pre-distribution from other community assets if there are any, like if there's a community savings account or investment account and you want to be able to get funds out of it, or even if it's in one party's name, you might be able to seek a pre-distribution. If the other party has access to resources and you don't, and they're working and you're not, you might be able to seek temporary spousal support. The restraining order doesn't stop you from seeking any of those things, but yeah, I don't know if that helps or not, but that's kind of what I got.
Yeah, some of the questions, guys, are really hard to ask just because they are really specific. So I'm not able to ask all of the questions that are being posed, but trying to answer as many as
I'll
we
take
can.
one more before we wrap up, or
Okay.
two more.
Yeah. How difficult are contempt of court orders? Is the King County Court very forgiving? That's the question.
Um, I chuckle about that because contempt is thrown around a lot, and contempt is a very serious thing. And it's not about if someone's forgiving. If you violate, like, for example, the parenting plan, and you can show that this person absolutely violated the plan and the language of the plan with their actions, it doesn't matter if someone's like, oh, you haven't done it before. That should be contempt. When to seek contempt is another thing. Like courts sometimes will be exasperated with you if you seek contempt because someone didn't follow the exchange location and they were like late once or something. Don't seek contempt for that. Do seek contempt if someone withholds your child. But contempt is something I will tell you based on experience. You don't know what's going to happen. It shouldn't be subjective, but sometimes it is. It's going to depend on the judicial officer and the facts of your case. And you could be in a situation where you bring a contempt motion and you're so sure that this is actually contempt, and yet the court finds it's not. Or you could be in a situation where you think the other party had a weak case and all of a sudden you're in contempt. Like it really depends. But it really is a serious thing because two findings of contempt on residential contempt and a parenting plan within a 3-year period is adequate cause to change a parenting plan. So courts are very careful about whether they're going to find contempt, and they really want to make sure it's not because they're being forgiving, but they really want to make sure it was actually contempt and that there actually was bad faith and it was intentional and it actually violated the plan. So I would say that, I mean, it happens. Contempt is found all the time, but there's plenty of times it's not too. So you need to be very careful before you bring a contempt motion because you don't want to end up paying someone else's fees. But you should bring a contempt motion if you're in a situation where you feel that you need to hold someone accountable, because if you don't, it's very common. It goes to the closeness and time thing before. Someone will be like, well, this person violated the plan like a year ago. Okay, that's great, but you didn't do anything about it then. And you can seek contempt, but it's the question, it really is going to cut against the credibility, and the facts might be more blurred if it's been a long time.
Mhm. Thank you. Okay, I'm gonna ask another one. This one's
Last one.
another bit confusing, so I'm gonna try to bear it down. They're saying they have a protection order. Husband has control of the finances. Concerned that he's gonna be shady with the finances, basically. Wondering if it would make sense to get joint accounts under her own name, maybe. Trying to figure out how to protect self financially,
Sure,
basically.
sure. That's actually a good question. If you're trying to protect yourself financially, what I tell a lot of people is if you've only ever had joint accounts and you don't already have an account of your own, open one. Yes, open one. That way you have a place that you can receive money and draw on funds from, or have money transferred into by court order or agreement, or put your own money in if someone gives you money. Open your own account. That is definitely is definitely important. And same thing too with credit. If you have credit cards and they're all only like an authorized user on someone else's, get your own credit card, establish your own credit, even if you've never had it before.
Thank you. Okay, one last really short one. How long does it take in a CIR case to to prove there's a CIR? And what is a CIR in brief terms, so people who don't know?
Committed intimate relationship is a stable, unmarried relationship, marriage-like relationship where people do a variety of things. First of all, the purpose of the relationship. Purpose of the relationship is for mutual love, trust, respect, understanding, intimacy. It's a relationship. It's not just a roommate situation. You can live with someone that's a roommate for a long time. It's not a CIR. It has to actually be a relationship where people pool resources. That might mean you have some joint accounts. That might mean, or that you contribute to things even if you don't have joint accounts. One person pays the mortgage, other person pays the utilities, those kinds of things. You pool resources. Another thing, as well would be that you hold yourself out as a couple. People know that you're a couple and you don't just hide it from anybody. Everybody knows it's open. The other thing would be continuous cohabitation. Continuous cohabitation is a hallmark of committed intimate relationships. You can be dating somebody for a really long time and not live with them, and it's not a committed intimate relationship because it requires continuous cohabitation, usually for at least 2 years. I'd say 2 to 3 years is right in that spot where committed intimate relationships start to be considered and found. How long does it take? Well, depends on where you are, but I will reiterate what I said earlier. The family law cases are marathons, they're not sprints. So if you filed a committed intimate relationship case in King County, you'd get a trial date that's like a year from now. And that would be the soonest your case would go to trial. However, that being said, over 90% of family law cases never go to trial. They don't go to trial. And that's why, because they're resolved through negotiation or mediation in a situation like that. So in this kind of a circumstance, the answer to that is it depends. And you could end up in a committed intimate relationship where both parties are really motivated to resolve it. You're able to get financial transparency through discovery or otherwise, and you're able to negotiate and you don't end up going to mediation and you settle your case in a couple months. That's a great scenario. Or you end up doing a mediation and it gets set earlier and you settle it within the first 6 months. That's pretty fast. If one party really doesn't want to do that and it's being what you would call dragged out, which I would call following the case schedule, you can't require someone to mediate in a case like if it were in King County for about 10 months. So you probably would mediate then and hopefully settle. And if not, you'd go on to a trial. So it's a marathon and not a sprint. But you also can't settle a divorce case or a committed intimate relationship case if you don't have access to all the money and know what you're settling on. And that can take time to do.
Yes, thank you. And thank you for all the great questions. Apologies that some of these are really specific to, your situation and we can't give you specific information there. So what I would say is consult with an attorney. Whether you decide to contact Michelle's firm or another firm, contact an attorney and ask your specific questions because some of them we can't answer in this context. But thank you so much for coming. Thanks for asking your questions. Sometimes when you ask questions, there are questions that somebody else didn't think to ask, and it can be extremely helpful to everybody who arrives at these or who might watch them later on our YouTube channel. So thank you so much for being a part of it. If you have any interest in reaching out, please reach out to Michelle's firm for consultation for legal services. If anybody is interested in therapy or counseling services, please feel free to reach out to me. And we hope to hear from you. Take good care.
Thanks so much. Have a great day. Bye-bye.